Good morning everybody from Europe, and good afternoon to all of you who are listening to us from China. Welcome to the EU SME Centre webinar series. My name is Anne-Laure Maddy and I am the Communications Manager at the EU SME Centre. So today we will be looking at how to manage contract terms and minimize risk in China. Just before we get started, I would, however, like to just run through a couple of quick processes with you. You will see on your panel a little hand. If you can click and raise your hand so that we can see how many of you are with us here today, how many of you can hear us. So I can see quite a few of you are, yes, we have quite a large following today. That's good to see. During the webinar, you will be able to post any questions that you have. Your microphones are muted. I'm afraid with so many people listening to us, we'll only be able to accept some written questions, but we will try our best to answer your questions throughout today's webinar. If for any reason we don't manage to get to your particular question, you can always send us your inquiry to our email address shown at the bottom of the screen here, inquiries@eusmecentre.org.cn. Now, I can see that today there are a few people that know us already, but I can also see quite a few newcomers. So I'd just like to take a couple of slides, a bit of your time, just to introduce to you the EU SME Centre. So the EU SME Centre is a project funded by the EU, which is providing practical business support to European small and medium enterprises that are investing in China or exporting to China. We provide free information and advice, as well as trainings and events to support you in your internationalization efforts to China. And our office is based here in Beijing, where we have a team of around 15 full-time members of staff. In terms of our services, so inquiries, you can send us any inquiries that you may have covering the areas of business development, legal issues, standards for importing your products to China, and human resources. All of our information and access to our business tools can be found on our website in our Knowledge Center, and there we have very practical reports on overviews of different sectors, industry sectors in the market, as well as practical guidelines and case studies sharing best practices and procedures on how to conduct your business in China. We also have some very useful online databases showing trade fairs and exhibitions upcoming in China, as well as a whole directory of specialized service providers. You can also see our events calendar online and see what trainings you have coming up in your area, as well as our upcoming webinar series. So, let's get down to today's topic, which is managing contracts, and we'll actually be looking more specifically to sales contracts in China. Now, many of you may already know that negotiating contract terms can at times be quite a difficult and lengthy process. Often companies can also be quite quick to sign on the dotted line without really thinking of some fundamental clauses and steps that will actually protect their businesses in the long term. And I think today's webinar is going to focus on those aspects, on how to protect your businesses when negotiating sales contracts in China. So without further ado, I'd like to pass you over to today's speaker. Today's speaker is Ludmila Hiklova. Ludmila is our in-house legal expert and market access advisor here at the EU SME Centre. And I will pass over the microphone to you now, Ludmila.
Thank you, Anne-Laure. Good morning and good afternoon to everybody who has joined us today for today's seminar. So what we are going to do today. First, we would like to share with you a few recommendations even before you start your contract negotiation. Then we will focus on sales and purchase contract between European seller and Chinese buyer. We will focus on the provisions you shall always include in your contract, and will give you general tips for concluding a fair contract. As Anne-Laure pointed out at the beginning, EU SME Center is helping European small and medium-sized enterprises investing and exporting to China. Therefore, we have chosen as our contribution to our purpose, sales and purchase contract from the point of view of the European seller. Before we start the presentation and we go directly to the topic, we would like to a little bit understand what our audience is. And I would like to ask Anne-Laure to launch our first poll. And the question is very simple. If you please can tell us what's your experience with exporting to China. Have you concluded no contract yet, or are you just now in the process of negotiation, or are you negotiating and contracting on the regular basis? So we have seen that voting is in the progress. We will give you few seconds. Now, yeah, we have concluded, and we've seen that majority, especially slightly more than 50% of you have not concluded any contract yet, which is, I wouldn't say it's excellent, but from the point of view of the webinar, it's excellent timing, because we hope we will give you some useful advices which will help you to strengthen your position and avoid risks or minimize the risks. So then back to our presentation. Before we will start going provision by provision in the contract, we will just very quickly give like a before start minimum. When you want to export your goods to some market, you definitely need to know if it is the right market. So pay attention if China is really a good market for your products. There are many ways how to find it out. You can use as well the services of our development, business development colleagues here in the USME Center. But always, of course, it's not the only way how you can get the information. Then it's important as well that you verify what category your product belongs to. China, as any other country, or most of the countries, controls or exercise controls over the goods moving into the country, and they divided goods into 3 categories: prohibited, restricted, or for free import. Then when you know that there is a product, there is a market for your product, and you know your goods is allowed for the market, you might be interested what certification and licenses you need. And one additional advice is that there are only certified importers are allowed to bring goods or the goods to the Chinese market. So be interested and verify if the importer you are cooperating with have an appropriate export-import license for China. Then after assessing your product is suitable for the market, assess your partner. Take into consideration how did you meet the partner. Always ask for its business license and special permits. Keep personal contact, and there are more other useful advices which we don't have time during today's webinar, and in this webinar it's not meant to be introduction to this topic, but we have make a summary into our brochure, Knowing Your Partners in China, which you can download on the websites. You can see at the bottom of the slide. Now, how do you stand in the negotiation? It's very useful always to know your bargaining position. Why it's practical? Because then you can use your contract template, simply the template which is your own and you are familiar with. Have you asked for the other offers? Are you familiar with? Uh, of course, you will pay different attention when it's going to be only one-off contract, or if you have intention to conclude a long-term framework contract.
Thank you, Ludmila. Actually, just before we go further, probably one of the first steps going into your contract, or one of the first elements, will be your the law that will govern the contract. And for this, we will launch our second poll of today. So, from your perspective, which of the following laws do you think should be governing your contracts in China? So should it be any law, the law of the seller, only Chinese law, or only Chinese or Hong Kong law? So I give you a few moments just to contemplate that and to post your responses to that. Okay, a couple more moments. Right. So interesting. We can see then that actually most of you think only Chinese law. So you will see those appearing shortly. 35% only Chinese law. So I pass back to you, Ludmila, to discuss this point.
Thank you, Amor. And I'm really grateful for your answers, because it really shows that maybe even you have not concluded any contract, you have already some experience with the Chinese counterparty. Of course, most of the Chinese parties, they would insist and they would, I would say, push you to accept the Chinese law. However, you don't need to accept that if, of course, you have some bargaining power. Maybe I should explain at the beginning what the governing law, what does it mean? It's simply the option given to both parties to agree beforehand, before the contract is concluded, and put the special provision into the contract, what law can be used for the contract when a dispute between them arises. And there is an option given to the parties. If the exporter is a foreign company having no presence, means no company, non-registered company in China, you can basically choose any law. However, if you are a foreign invested company registered and settled in China, you don't have that option. But I believe that most of you are the European-based companies who does not have any subsidiary in China yet. So you are free to choose governing law. Now on the next slide you will see what are the most recommended and practical options. Of course, the best one is your national law, because it's law you are familiar with. You know, probably the legal advice is more accessible. Second option is Chinese law, means the law of your counterparty. However, if you are not able to reach agreement on any of those options, then you may go for the compromises, and especially and only in the case of the international sale of the goods. You can use the UN Convention on Contracts for the international sale of the goods, which is most of the European Union countries are parties to this contract, except the 4 countries you see below: Ireland, Malta, Portugal, and the UK. And of course there is a fourth option. You can use any other law you are well familiar with. But those 3 first options, national law, Chinese law, or the UN Convention, are mostly recommended one. Now, starting from the end, Why we start from the end? Because it is the most occasions when someone or most of the people starting to be interested what is really written into the contract. We are receiving daily quite a few inquiries coming from the breach of the contract. People or the parties, they have a contract, but they didn't pay enough attention to drafting special provisions. And now they are, when the problems arises, they are start to think about how to solve the problems. Usually, in most cases, it's too late, and damage has been already done. Probably you have seen that you have heard that in China, contract is not so much important as the Guangxin's relationship. Well, relationship is very, very important, but valid contract in your hand adds to your security immensely. And of course, when the problems arises and you need to go for the dispute settlement, either to the court or to the arbitrator, then they will be interested what evidence and especially what papers, what valid papers you can submit to them. So what happens when the friendly negotiation fails? Firstly, you calculate your loss and compare it with costs for the dispute settlement. Means fees for the court or arbitration, lawyers. It's important to mention that fees for the lawyers will be in most cases covered by you, even if you win the litigation. There are as well fees related to the notarization and the translation or the traveling. One again.
Sorry about that. I think we were experiencing a little bit of connection problem there, but maybe, Ludmila, we can go back over this point of when the negotiations get a little difficult.
Okay, so let's go a little bit back and start with when friendly negotiation fails. So first thing you should do is calculate if it makes sense to start dispute settlement. You should calculate your loss and compare it with the cost for the dispute settlement, which means not only arbitration and the court fee, but as well fee for the lawyers. And please be aware that the lawyers or the fee for the lawyers will be covered by you, even you win the case. And of course you add that additional fees for the notarization, translations, traveling, and so. What is important to do as well is to investigate if there are any assets available for future enforcement. What does it mean? It means if your Chinese party you litigate or you have a dispute with has any assets which you can then enforce the judgment on. Now, very quickly, what options, and most often options you have for the dispute settlement. We have a very nice guideline on the dispute settlement in the website, so I will go really very quickly through these two slides. Generally, it is not much advised for the foreign companies to use the litigation as a mode of the dispute settlement. Why is that so? Because it's less flexible, it may take longer. However, if you have no other option, just go for the litigation in China. Go for the litigation in China, not in your home country. It is because most foreign court awards are not enforced in China. If defendant is a Chinese person, it is very likely that he or she has assets in China which is good for the future enforcement of the judgment. In comparison to the litigation, arbitration has a lot of advantages, and it is always recommended option. Arbitration, even international arbitration awards, are enforceable in China. You can choose international arbitration bodies like Hong Kong and Singapore are most often ones, or even the Stockholm, or any other country which is part to the convention, to the New York Convention. Of course, you can choose as well the Chinese arbitration as an arbitration commission in CETAC arbitration commission in Beijing. But there is one condition, important condition, in order you can use the advantages of the arbitration, and it is that you stipulate really clearly in written in the contract that you agreed on the arbitration body, that you agree what matters you will be subject for the arbitration, and you may add provisions about the language, place, and setup of the arbitration tribunal.
So, Lamilla, a quick question I see coming in here on arbitration. A company says that they currently don't have any dispute settlement clause in their contract. So what should they do in that case?
Yeah, unfortunately there is often a case that the parties forget to input that provision into the contract. In such case, they have basically two main options. First one, even they have already dispute, they agree that they will choose arbitration for the dispute settlement. But as I mentioned a couple of minutes ago, the agreement must be in written, and they have to agree what arbitration body is the one they have chosen matters for the arbitration. If they are not able to agree, then very probably litigation will apply and will be used. And if it is in the hand of the European company, then we suggest go and to litigate in China. Of course, first you should, as I mentioned a couple of minutes ago, you should know that the counterparty has any property in China, and then start the litigation after comparing all costs and your possible losses. All right. So now, when we are when we are in the middle of our presentation, start from the beginning, but not from the beginning of the presentation, but from the beginning of the contract. And before we start on the first page, which means parties identification, I would like to Laura to help me to launch our third and the last poll. And the question is, what's your opinion on the Chinese partner name? In what language it shall be written in the first page on the contract? And there are options: English, Chinese, either of them, either or only both of them. And your voting coming in. Yeah. We will wait a couple of minutes, a couple of seconds. All right, we close the poll. And the result is 40% only both of them, and 31% for the Chinese. I think it's very correct answer. Of course, the safest way is both of them, but it doesn't need to be only both of them. It's good to have both of them, but the Chinese name is most important. Okay. So case for this is what you will probably receive when you ask for the one. This is quick translation which shows what information you can learn about your contracting party from the business license. You don't need to be in a hurry reading all those informations. As I mentioned at the beginning, all the whole presentation is available or will be available on our website, so later on you can return. So now we go the most important provisions of the contract one by one. When you have identified the parties, you would like to specify the object of the contract. First, before you bring any of your product to China, make sure that you protected your IPR, your intellectual property rights. If you do not know how to do that, we have a very capable sister project, IPR SME Help Desk, and people that are very qualified to answer any of your questions. You may find contact on our websites as well, but if you put in the Google search IPR SME Help Desk China, you will find them as well. You are probably the most qualified people to make a specification of the product, so I think I don't need to advise on this. You definitely need to prepare some certificates for your product. We advise you really pay attention to quality and the quantity, and especially to the inspection standards and method of the inspection. Choosing of the and appointing of the inspection company will be probably on your Chinese importer. However, make sure that you know this company, or at least you got some references about that company. That this company is independent, reputable, and trusted. Pay even such attention to minor things from your point of view might be like terminology. What measurement do you use? The weight, time, is it day or calendar day or working day? All is important. Method of packaging as well, of course. Now the delivery. Stipulate in your contract time and place of transfer of the ownership title and all the risk. China widely use Incoterms. When you make reference to the Incoterms, specified what version of Incoterms you use. CIF and FOB are most commonly used Incoterms for the international trade in China. Provisions specifying loading port, port of destination. Then not only at the beginning, but during the deal, you probably would need to communicate with your counterparty. So agree on the way how you will exchange information. We recommend it is in written or at least in the email, but later on confirmed in a written mode in case you need it as a proof for the possible dispute. Make as well sure that you communicate with not too many people. Have contact persons, one or maximum two authorized persons. One of the conditions which might be useful to specify in the contract is as well a period for announcing of the non-conformity of the goods to you, after which the counterparty would not be able to claim any mistakes or any warranty. Yeah. Now the payment. The provisions which are probably most interesting for the European exporter. We will have in the first quarter of the next year, we will have separate webinar. We will have separate webinar on the payment conditions. In the first quarter of the next year, we will have a separate webinar on the payment conditions. When you are exporting to China, how you will get paid for your products. So I will go through the next slide really very quickly and touch only the most important topics. So when you set up the price, be always interested what is included in the price. Does it cover VAT tax and import tariffs or the other fees? Of course, usually it is on the Chinese importer to pay all those fees and the taxes. However, it's good to be informed beforehand. Then, because China exercises foreign exchange control, RMB is not freely convertible currency, and therefore this setup and agreement on the currency in which you will be invoicing is important. Of course, the Chinese party would like to pay in the RMB, however, you would like to be paid in the euro. If you agree on the euro settlement, it will be, of course, a little bit tricky for your Chinese buyer, but it's not impossible, and it is more and more common that the Chinese companies pay in the euro or US dollars or any other freely convertible foreign currency. However, always insist that on the side of the Chinese buyer is a reputable bank. It will not very probably be one of the big banks in the Europe, or I mean, you don't need to rely that it will be HSBC or the Standard Chartered or any other bigger bank, because Chinese companies mostly communicate and use services of big Chinese banks. So if you can see in the name of the Bank of China, Bank of Communication, ICBC, or China Development Bank, there should be they should add to your security that those are reputable Chinese banks. Same attention as you pay to the name on the to the Chinese name on the contract. Pay same attention on the name on any other document, including bank account information. you might be interested as well who pays bank charges and other fees. It might be not big money, but however, it's good to be clear and avoid misunderstanding and surprises later on. Now to the method of payment. Letter of credit or we have seen one or two cases of the deposit. Means that the European exporter agreed with the Chinese partner on the deposit. However, do not rely much on this option because it's not so common to see the deposit. So if you ask simply the question, what payment method is the most often and most commonly seen, is letter of credit. Of course, when you have a long-term relationship later on and your partner is trusted one, you can agree on other more advanced method of the payments. One note which is related to the right of set-off. If you have a contract which involves several deals in one, then insist that you got a written notification if your Chinese party would like to use the right to set off your bill.
Thank you, Ludmila. We have a question actually coming in about foreign exchange control and the procedures on that. A company saying that they have a client that's telling them that they cannot pay in time due to the delays in foreign exchange procedures. Now they want to know, is this a valid excuse? Is it really such a complex procedure here in China?
Thank you. It may be excuse, but it may be true as well. As I mentioned, the foreign exchange control and administration related to the foreign exchange is very complicated. So it might really be true that this procedure takes several weeks. So, however, you still keep contacting your Chinese partner and asking the questions. However, it does not mean So the reply to that question related to the procedure on the foreign exchange control was that likely to be requested from you for the letter of credit. It's, of course, it's invoice with contract number, description of the goods, unit price, total amount, gross, net, and weights of the goods. Plus, there is a report from the inspection company on the quality and the quantity, certificate of origin, bill of lading, and packing list. It does not mean that there is a full list of the documents you might be asked for. It might be other documents, depends on the bank, it depends on the status of the Chinese buyer. And as well, they will check not only the list of the documents, but they will go in details. There might be some additional requests on the content of the invoice, for example. Now, we went through most of the most important provisions in the contract. However, there are other rights and obligations which you may wish to put into the contract. For example, who deals with the customs and consignment. Don't take it as a granted that it is usually the importer, even if this in more cases, but be precise in that. For the China, it's very important what certificates need to be obtained. So make sure that the obligations between you and the Chinese party are split and are clear. In the contract, there might be allowed assignment or subcontracting to another party. It's important to know who the other party is, and you might wish to approve it in written. Why is that important? It's clear because then you will know whom can you chase at the end of the day when something goes wrong.
And in that respect, Ludmila, is email correspondence considered evidence or proof?
Yeah, I mean, email is very often way of the communication. However, I would be very careful when using email as evidence. In most cases, it's not taken as a valid evidence. It might be like something like a supporting, but it's not. I would not rely on it as evidence. Even if you agree in the contract that you will use the email correspondence, it always depends on the position of the arbitrator or the judge, how they will evaluate this as evidence. Now, breach of the contract. This is the situation which everybody would like to avoid. However, it sometimes, unfortunately, often happens. And it's good to know what can be result of the contract, breach of the contract. It can be, can ask for the remedy, it can be payment of the damages, or even the contract dissolution. All these three options can stand alone, but all these three options can be combined together. When it comes to the loss assessment, So breach of the contract. We have finished explaining what could be the result. Loss. Are first the mutual agreement, of course, or the mutual agreement on the method how to assess the loss, or you can leave it to the dispute settlement body. Now we are coming to the last page of the contract, which is signature and affixing the company stamp or the contract stamp in some cases of the company. You can see the nice example of the company stamp on the slide, and this is how the company stamp shall, of the Chinese company, stamp of the Chinese company shall look like. Chinese name must be always same as on the business license, same as on the first page on the contract. If it is a company shop, it's only in the Chinese. Bilingual shops can be only in case special contract stamps. The shop shall be affixed with the red ink, and in the middle shall be 5-pointed star. If you, maybe I should, or definitely I shall mention the importance of the company stamp. The company stamp in China is equal to the signature of the CEO of the or the board of directors of the statutory body in Europe. Means it's a very powerful one. If you want to add to your security, then you shall ask, or you shall insist on adding a signature of the legal representative of the company. It is the, as I said at the beginning, it is the only person who is authorized to sign and oblige on behalf of the company. But please make sure that the person who is signing is really a legal representative, as it's not any other person. Or it may be any other person, but in that case, he or she shall have a power of attorney. And of course, there are other important provisions which we do not have time today to go through, and those are mostly the provisions that nobody pays attention to. But you can see at least the list of some of them, and it's strongly suggested you include them into your contract. I would mention only a few of them. For example, coverage of the unusual risks, or the confidentiality, or the language. And now we come to the last slide of our presentation, and take your time, don't rush. It needs to be said that the good contract and quality contract is a result of cooperation, not only result of drafting of the lawyers. There must be more people cooperating in that. It must be your finance unit and the business people. One practical suggestion, it is preferred that you ask your counterparty sign the first. And last advice, do not sign unless you are really sure that you are satisfied with the content of the contract.
Thank you very much, Ludmila, for such a comprehensive look at contracts and the fundamental clauses that need to be considered. We have had quite a number of questions today, and so I'm afraid we'll only be able to tackle one or two. But first of all, I see, let me take the first question on the list here. Ludmila, is it possible for a company to open a bank account in China without having any representation here in China?
Honestly, I haven't seen such a case, opening a foreign company opening account in China without having a subsidiary or the branch or the representative office. Yeah.
Okay. And there was a question a little earlier about taxes and fees applicable on the import. So that's going back to importing the goods through customs. What taxes and fees would be applicable if you are when you are importing your goods here?
Yeah, for the import of the goods, there are few taxes and fee applicable depending on your product. Most often it is import VAT, cost customs duty. In cases of the luxury goods, it is consumption tax, and in some cases they may be applied as well the motor vehicle and vessel tax. So this is for the question on the tax and fees.
Okay, and just going back to applicable law of the contract, that was earlier on in the webinar. There's a company here that says that in their contract they do not have a clause that specifies the applicable law in the contract. So what would happen in this case?
I think if there is no dispute between you and the other party, then you don't need to too much care about the having or not having the applicable law. The problems arises when the dispute comes, and then it comes. If you have an arbitration clause in your contract, then the arbitrator will decide which law is applicable. If you don't have the arbitration clause in your contract, then you will go for the court for the litigation very probably, and the judge will decide what law is applicable. General guideline: it is the law which is the most closest to the contract, and usually it is either your national law or this law, it's a Chinese law.
Okay, thank you, Ludmila. Well, that actually comes to the end of today's webinar, and first of all I'd like to thank Ludmila for presenting today. I would also like to thank all of you for attending. Now, we did get a long list of questions, but if we haven't managed to cover your question today, do send them to us through inquiries@eusmecentre.org.cn. For those of you who are interested in receiving the presentation, this will be, the presentation today has been recorded and will be put online over the coming days, and you can find this from our website in our Knowledge Center. We will also be sending a copy of the presentation to you all after this webinar via email. This is the final webinar for 2012 from the EU SME Centre. So we will be back in the new year, however, with a whole new series looking at practical issues for developing your SME business in China, looking at distribution channels, looking at finances and payment methods. So do keeping connected to us on social media and through our website. I would like to wish everybody a very Merry Christmas and a Happy New Year on behalf of the EU SME Centre team. And just before you log out today, you will probably be given a link to a very short survey on today's webinar, and we do value all your feedback, so do take a couple of moments to fill that in. And then for further information and contact with us, I revert you to our website where you can access all our online services. So with that, we will leave you today, and thank you for listening. Goodbye.